Good evening, Judge Nobe.
Good evening, DCJ.
Are you well?
I'm very well. I'm very well.
Are you comfortable?
Thank you. Yes, I'm comfortable.
All right. Oh, let me first apologize for keeping you waiting for so long and interviewing you at this ungodly hour. I know I've been subjected to this torture of being interviewed at night. I know it's unpleasant, but please bear with us.
Yeah.
I promise we'll be gentle with you just to make up for that. Okay.
No, it's understandable.
You hold a number of academic qualifications, BUris, LLB, LLM, and a diploma, which you've abbreviated, but it looks like a diploma in environmental law.
It is, yes. It's diploma in environmental law, which was actually changed into master's.
Yes.
Yes.
And you did the diploma and the master's at the University of Natal,
Yes.
having acquired the first two at the University of Zululand.
Yes.
Your journey in the legal field started in 1982 already when you joined the Department of Justice as a court interpreter.
Yes, in 1982. Yes, I started as a court interpreter in 1982, only appointed as a magistrate in 1986.
But you had worked. You became a prosecutor.
Yes,
In between?
In between, I became a prosecutor.
For 2 years. Then you rose to regional magistrate, but did not stay long there. You were there for a year?
Yes, I think it 2014, 2015. Yes, 2014, I was appointed in
Yes.
2014 as a regional magistrate.
And you started acting as a judge in 2016 until your permanent appointment in late 2021.
Yes, in actual fact, I started acting as a judge at the Land Claims Court in 2006 during the time of Judge Palm. But it was on and off. 2006, I acted 2007, 2008, 2009. But in 2016, then I acted continuously until I was appointed.
Okay, your questionnaire is not very clear on this, so I was going to deal with your acting stints in silos. So you say since 2006,
Yes.
you've acted in the Land Claims Court.
Yes.
Now, until your permanent appointment, for how long had you acted in that particular court? No, not in the High Court now.
Until my permanent appointment, I acted since 2016. Then I acted continuously for 5 years until I was appointed.
And you have written judgments in that court.
Yes.
How many? Can you remember? Is it a lot?
A lot of them. I'd need a trolley to bring them here.
Any of them taken on appeal, successfully, unsuccessfully?
Yes, at least there were 2 which were taken on appeal, where my judgments were upset. At least 2, but about 5 were confirmed.
So your truckload remains almost intact.
Yes, I'd say
Okay.
so.
Have you played any leadership role in any of these courts? Magistracy, in the Land Claims Court, or in the High Court?
Yeah, with me, I would say that I come from the era where the magistrate, as the head of office, was actually in charge of almost everything. When we were doing agency functions, we were doing home affairs work, we were doing revenue work, paymaster general's work, we were registering cars, we were doing almost everything. We were paying pensions, we were paying wages for for health workers, almost everything, and we were supervising all the clerks at the office, we were supervising all the prosecutors at the office, almost everything we were doing there. We were writing reports on all of them, on all members of staff. And then I also became the second in charge. I became a second in charge for about 2 years. Then I became the head of office. The head of office, I think it was for about 7 years. And I was in charge of the area cluster. I was the area cluster head, in charge of about 7 magistrates who were under me. I was writing reports on them. I was checking their work. I was doing training inspections on their work. And I went down to Durban in 2000. I worked with the chief magistrate, Mr. Mabaso, and we were doing case flow management with him. And he made me to write the reports, case flow management reports. We would collect reports from all the other area clusters, and then I would write the single report based on the reports which I received from the other area clusters. And when I was the area cluster head or sub-cluster head for Mlazi, I continued with that function of writing reports on them and doing all the administration, judicial administration, as well as other type of administrative work.
Have you played any role of such responsibility in the Land Claims Court?
At the Land Claims Court, I have not acted at the Land Claims Court. Well, I think we all know that this is the type of work which you cannot just volunteer to do. It is the prerogative of the JP to appoint a person to act. You can't volunteer to act. But yes, with the experience, the acting experience, or the experience being the head of the court, which I have, I think I have enough experience in leadership position.
All right. Are there any challenges that you have identified in the manner in which the court is run, or in any area that you think might require improvement to beef that court up? In other words, I just want you to tell us, just briefly, what your view of the state of that court is,
Yes,
and your vision for it.
Yeah, no. I think that the first thing which must be done there is to sell the court. That is the first step, is to sell the court to the public. We must sell the court to the people, because many people do not know the court. They do not know what work is done there. And many people, more especially people from the rural areas, do not know how to access it. They don't know how to find, where to find it. So I think the first thing now, or the first problem, or the first thing which must be done, is to sell the court, either in cooperation with the Department of Justice or in cooperation with the Department of Land Affairs, in the sense that we must start maybe advertising it in the form of, maybe can be pamphlets which can be distributed. I think many of us will remember at the time when land reform legislation came into operation, when we started working with land reform legislation, the Department of Land Affairs used to publish certain pamphlets, and where things were explained, who is the occupier, labor tenants, and all those things were explained in those pamphlets. I think now we need to revive that system. We need to revive that thing, and let the people be aware of the court and what the court can do for them, because this is their court. That is the first thing. I think the second thing is to strive by all means to let people access the court. Justice to the people. We must take justice to the people, not people to justice. But we have problems then of money. Many departments do not have money. But I think we must try to minimize where we can minimize and try to meet the people where we can meet the people. I think there's no way in which we can avoid going to the people. Despite the fact that we do not have sufficient money, but there is no way we can avoid going to the people so that people can see the court coming to them. Insofar as traveling is concerned, maybe traveling expenses, if you have got a relative that side, you may arrange with a relative to stay with the relative so that you minimize the cost. Or we can just come up with something and to see how we can assist the people to access the court. Well, I think in terms of the land, on the Land Act now, the minister will be able to appoint a certain place where, in terms of Section 24, a certain place where we can hold the court so that the court can be closer to the people. But the problem will be the budget. But as I've said, if we are actually willing to go to the people, you can't imagine the excitement people have when they see the court coming to them. When we go out for inspection in the far-flung areas, you can't imagine the excitement they have when they see that the judge is here, when they take you to sugarcane fields, when they point their graves or they point their relatives' graves in the sugarcane fields, when they blow their trumpets. When they blow their trumpets, driving their cars into the sugarcane fields, pointing at their graves and pointing at the remains of their homesteads there, you can see these people are actually excited that the court is here now. So today we are getting back our land. So I think that is the function that is something which we must try to do. And also we must try and instill confidence. We must try and instill confidence in the members of the public that the court is actually working for them. I was doing an inspection in local somewhere there in the northern Zululand. And when I asked this old lady, so how did you leave this place now? How did you leave this place? Because she was showing me the homestead where they were staying. How did you leave this place now? And she said, no, we were chased away by the whites. They came here with dogs. We were bathing here. They came with dogs and they called us, come. Go over the mountains and stay with other baboons. Now you see that if there's still that mentality in their minds, now if they see a judge coming to them, they think now, today, the land is coming back. That is why they start blowing their trumpets and carry their shields when they go to show you these things, the remains of their homesteads and all these things. So I think that is the vision I have. First of all, is to sell the court. Having sold the court, must make sure that we take justice to the people, not that people must go to justice. And thirdly, we must instill confidence in the people that actually this court is working for them and that it is going to assist them to get back their land, which they believe was stolen by white people.
Anything else you want to add? Have you finished?
No, I'll stop there. I think that is the most important thing which we must do for this court.
Thank you, Judge Ncube. I'm going to hand
Oh,
over
also,
to...
I'm sorry.
There's more.
I'm sorry.
Carry on.
I'm sorry.
This is your moment to...
Yes, I have also realized that sometimes we work with the magistrates. We work with the magistrates. We do their reviews. We look at their matters. We review their matters, and sometimes in our judgment we criticize them. But there's never been a time when we tried to empower the magistrates. We have empowered the other stakeholders. We have empowered the attorneys. who appear before us, we train them, but there's never been an occasion when we organized maybe a workshop for magistrates where we could tell them how to do things and where we could tell them where they go wrong. I think that is another thing which we must try and achieve when we are going to work for this court. Thank you.
Thank you, Justice Ncube. AJP Mir, do you have questions for this candidate?
Yes, I have two questions. How would you achieve your vision of taking the court to the people, given the budgetary constraints which we face?
Yes, as I have said, I think we have relatives everywhere. We have relatives everywhere. We can try and get accommodation wherever we can get accommodation. If I have a brother in Zululand, I can arrange with my brother to sleep at his house and avoid paying for the hotel.
No.
If I need transport, we have cars. We can drive our cars and go there and make sure that we are visible to the people. We must try something. So we can't just sit back because we say there are no funds, but we must try and do something.
Judge Ncube, but that doesn't cover our airfare costs, which you know are considerable when we have to go there as well. I'm talking about the very real challenges we face.
Yes.
It's not just a judge traveling and staying at a relative's house. There also, we travel with staff. We have to arrange venues, sometimes which have to be paid for when magistrates' courts are not available. So I'm really want you to engage me in how your vision would operate, taking into consideration the very real challenges we face with regard to budget.
Yeah, no, I think in case of venues, in a venue, we must make use of the magistrate's court because we don't pay at the magistrate's court, we don't pay for the venue. So we have a venue at the magistrate's court. We have arranged a venue. The acting JP will remember that we have arranged a venue at Camperdown, which we can use free of charge. Those are the venues we can use. More especially the magistrate's court, yes. I can only say the magistrate's court are the venues which you can use free of charge, which you cannot be charged for using them.
Thank you for that. Do you have any thoughts on how to deal with the bottlenecks caused by the Commission not being able to process particularly the old order claims?
I think there we must engage the Commission. We must have meetings with the Commission and ask the Commission to come out clearly and tell us what are the problems which they are facing and see if we cannot assist them in a way in order to solve those problems. I looked at the report, I looked at their report, the latest report which they compiled in January 2024. Well, I think there's a certain element of exaggeration. There's a certain element of exaggeration because if they say for them to finalize those claims, they will need 30 years and they need 172 billion rand. No, I think that is an exaggeration because that report is based on 6 months basis. 6 months basis, and 6 months basis, they were able, according to the report which they filed, in 6 months' time, they were able to finalize 163 matters. At the present moment, they say they are remaining with 6,139 matters. Now, for 6,139 matters, why is it going to take 30 years? Why is it going to take 172 billion rand? I don't believe it. There's an element of exaggeration, and I think if we can engage them and ask them to tell us their problems, we will be able to assist them to resolve these claims sooner than 30 years, which they project.
Thank you. No more questions from me.
Commissioners on the virtual platform, do you have any questions for this candidate?
No, thank you, Deputy Chief Justice.
Oh, thank
Nothing
you.
to say.
Commissioner Dodov? I'm sorry, I didn't see your hand.
Yes, I understand that it is very late, decision. Good evening, Justice.
Good evening, sir.
I can see that you ooze with confidence, like you did when we interviewed you in 2001. And just looking at your profile, that you started as a prosecutor in 1983.
Yes.
This is the year that our Minister of Justice was born. And I just looked at my bag. I'm sure no one of them was born by that time when we became the prosecutor. It's been a long journey.
Yeah, it's a long time.
Now, when we
Commissioner
interviewed
Dodov,
you,
may we please have questions
Yes.
for the candidate?
I'm just rekindling the spirits.
I understand.
When we interviewed you 3 years ago, you were very firm about issues of sustainable development and environment that must be integrated and encapsulated within the land issues themselves. What has been your experience since you were appointed as a judge to date in relation to those particular issues? What are your practical experiences? And taking this forward, what do you think can be your contribution in resolving the disputes or adjudicating the disputes that are before you as a judge?
Yeah, it's a pity that this environmental law field is a field which I think is a field which I could say people do not take it seriously. I don't know why, but the environment is very important. It is even entrenched in the Constitution in terms of Section 24. But it would appear that people do not take it seriously. In terms of sustainable development, we are looking at the people themselves to try and bring the cases forward. We don't normally get these cases. Since I started as a judge, there've never been an environmental case which has been brought before me. But as I said last time, we rely on the people to take the matter forward, to report environmental degradation to the police and open criminal cases, because there are criminal acts which are perpetrated by people. For instance, in the mining fields, we find that the mining company will come there and do the mining, and they leave everything open. They leave the holes there, which can injure people, and they do not rehabilitate the land.
No, it's okay. It's okay. You answered me because you're saying that you've not dealt with such issues since you were appointed. Thank you very much, DCJ.
Commissioner Clark?
Yes, thanks. Thank you very much, DCJ. Good afternoon, good evening, Judge.
Good evening.
Thank you. I've come across land disputes in the area of Amakosi, traditional areas, that are neither land restitution nor ESTA related. And I'm sure you are aware of such cases. And I come from the province where about a third of the hectares under Ngonyama Trust, for example. How do you see the jurisdiction of the land court extending to those areas?
Well, in terms of the Land Court Act, we have jurisdiction to decide any issue which arises from the application of that act, the Ngonyama Trust Act. So I think with that extended jurisdiction, maybe we can go back, as I've said that when I started talking, that we are from the era. We are from that era where we were even in charge of Amakosi. In our offices, we had a land dispute office. We engaged with Amakosi. We attended their meetings. We advised them of what to do. We were able to engage them when there were disputes between different tribes. We were able to engage them. Now, I think this court must actually go that route also. If there is a dispute arising from there, this court must be able to resolve those problems. When they are brought before us, of course, we can't go out and assist them unless they are brought before us. But I think with that experience, we can be able to solve any problem which arises from faction fights. For instance, there were faction fights those days, so we had to go out and negotiate with Amakosi, negotiate with the Zinduna, and I'm sure all disputes will be able to be resolved if you sit down with them. They are very patient people and they are very listening people. And if you sit down and talk Zulu to them, we say so, and talk Zulu to them, or talk to them and tell them to come up with the problems and try to solve the problems, there's nothing which can defeat us in that area.
Thank you, Judge. Thank you, DCJ.
Commissioner Moimang?
Thank you, Chief Justice. Good evening, Judge Ncube.
Good evening, sir.
Just going back to the point that you raised about the exaggerated billions of rands that are estimated to be able to address the backlog. I just want to get a sense from you, given the recently passed expropriation bill, which makes provision in terms of Section 12(3) for the expropriation with nil compensation, and also saying that could also be just and equitable, can be just and equitable to expropriate for nil compensation, taking into account other factors, but more than that, amongst them is the issue around the market value of the land, which is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial of the land. So I want to check as to whether, from your understanding, can that be an answer to the concerns that has delayed and also contributed to the backlog in terms of land redistribution and land restitution? Thank you.
You know, the issue of expropriation with nil compensation, I think it is a big problem. To me, it poses a problem in the sense that I can't see any landowner or any farmer who will say, I'm abandoning the land. Because the bill says nil compensation or expropriation with nil compensation can be in respect of the land which has been abandoned. Now, I don't think farmers knowing that there's such an act of parliament in place, will ever abandon the land. Secondly, nil compensation is for the land which is kept just to appreciate the value which we are not going to use for commercial purposes, and knowing the farmers, and the farmers knowing that there is such an act of parliament, I don't think they will ever just keep the land and do nothing with it. Those are the difficulties I have with this nil compensation, expropriation with nil compensation, because they read the bill. When the act comes into operation, they will know about the act, they get legal advice, and they know when their land can be expropriated without compensation. They know the circumstances under which the land will be expropriated without compensation, and they will try to avoid those situations. So to answer that question directly, I don't think it will be an answer to the problems we have.
Maybe let me just read to you what section 12.3 says. It says, it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances.
Yes.
That is an expressed intention of the legislature. If it's in the public interest and for public purposes,
Yes.
what is difficult in that?
Yes, but now what I'm saying is that it also says the circumstances under which expropriation can take place, expropriation with nil compensation. So now I was narrating the circumstances which the bill says those are the circumstances under which the land can be expropriated without compensation. Now I'm saying I don't see a situation where the farmer, because they mentioned the land which has been abandoned, or the land which is kept for purposes of appreciation and not for commercial purposes, and there are other grounds which they mention under which the land can be expropriated without compensation.
Thank you,
Justice.
Thank you, Chief Justice.
I'm sorry. Okay. So I was saying the farmers will always avoid those instances where the land can be expropriated without compensation.
Thank you. My apology, Judge Ncube, for the interruption. Thank you, Chief Justice. TCJ.
Thank you very much.
Judge Ncube, there are no further questions for you. That means we've reached the end of this interview. Is there anything you would like to find out from us?
No, there's nothing.
Okay.
Thank you very much.
Okay. Thank you so much for making yourself available for this position. You're excused.
Thank you.